Imagine you're on the floor of your company break room and the first thing your supervisor says isn't, "Are you okay?" It's, "Can you finish your shift?" What you say in the next few minutes can decide whether your workers' comp claim gets paid or gets picked apart months from now. The mistake that sinks most claims isn't made in a hearing room weeks or months later. It's made right here when you say, "I'm fine," out of instinct, and those two words come back as proof you were never really hurt. So here's exactly what to do in the first 24 hours after a workplace injury in New York that will protect your right to lost wages and medical benefits. Starting with a reporting clock that's already running, and the one form almost nobody hears about until it's too late, but will make all the difference in your case, especially if the insurance company wants to dispute or fight your right to benefits. The moment your accident happens, stop working if you can. I know that sounds obvious, but I've had clients push through a shift with a torn shoulder because they didn't want to seem dramatic, or because they were worried about looking replaceable, or God forbid, they were just plain out embarrassed. Every hour you keep working after an injury gives the insurance company a reason to argue it wasn't serious or that something else caused it later in the day. Stop and tell your supervisor immediately. Not a coworker, not a group text, your supervisor or whoever is designated to receive injury reports. New York law requires you to notify your employer, technically in writing in 30 days. And the clock on that notification starts the moment you get hurt. When you report it, say what happened in plain, factual terms. What you were doing, what caused the injury, what part of your body got hurt, even if it was your own fault. Because workers' comp is considered to be no fault, meaning if it happened, it counts, regardless of why. And that's it. This is where I see people talk themselves out of a claim without realizing it. "I'm okay, I just need a minute," becomes the sentence an insurance company quotes back to you at a hearing. You don't have to downplay it, and you don't have to exaggerate it either. Just describe what happened. Also, get it in writing. A verbal report to your supervisor is a start, but verbal reports get forgotten, reworded, or conveniently misremembered by the time a claim gets contested. You should ask for an incident report to be filled out, and if your workplace has one, request a copy for yourself. If there's no formal process, send a text or an email to your supervisor the same day and take a screenshot stating what happened and when. That timestamp matters more than people realize. Another important day one step, get medical treatment the same day if at all possible. This does two things. It gets you actual care, which is the whole point, but it also creates a medical record that ties your injury directly to that date and that incident. If you wait a week to see a doctor because you're hoping it'll just get better on its own, you've handed the insurance company an opening to argue that the injury happened somewhere else or really isn't work-related at all. Also, tell the doctor exactly how the injury happened at work, not "my back hurts." Say you were lifting a patient or moving a pallet or slipped on a wet floor during your shift. That detail is what connects your medical chart to your workers' compensation claim. Here's something that surprises almost everyone I talk to. In New York, you generally have the right to choose your own authorized treating doctor, which is great, not whoever your employer points you to. But there's a wrinkle worth knowing about. If your employer uses a preferred provider network, a PPO, you may need to start care inside that network for the first 30 days before you can switch to an outside authorized provider. Employers and insurance companies sometimes make it sound like their doctor is the only option, full stop. It's one of the more common ways claims get steered in a direction that favors the company and not the worker. Also, document everything starting that first day. We all have a computer in our pocket. Take photos of the scene if it's safe to do so. Whatever caused the injury, a wet floor, broken equipment, an unsafe walkway, write down the names of anyone who saw it happen. Memories fade fast and coworkers move on to other jobs. If you wait a month to ask a witness what they remember, you're going to get a shrug. Ask them the same week while it's fresh. You can simply record it on your device and write down what they say. Here's a word of warning about how insurance companies act these days. Be careful what you say to the insurance adjuster if they call you early on. And these days, they usually call fast. And while they're friendly, they are not your friend. Adjusters are trained to ask friendly, casual-sounding questions that are actually designed to get you to minimize your injury or admit uncertainty about how it happened. You don't owe them a recorded statement in that first call, and you're not required to guess at details you're not sure of. It's completely reasonable to say you're still getting checked out and you'll follow up once you know more. If you've already talked to an adjuster, though, before hiring an attorney, drop a comment and tell me what they asked you. It's one of the most common questions I get, and I want to know exactly what these calls sound like right now because insurance companies have been using this to feed it into their AI and figure out ways to deny claims quicker and even offer less money than your case is worth. Now, here's the part almost nobody talks about, and it's the reason I said there's a deadline hiding in that first day. When you notify your employer, that's good, but it's not enough. New York actually requires injured workers to file a written claim with the Workers' Compensation Board. It's called a C3 employee claim form. And there are strict time limits tied to both notifying your employer, as we already discussed, and officially filing your claim with the Workers' Compensation Board. I've had workers come to me months after an injury, insisting they told their employer. Great! But that's not enough. Unfortunately, while you might still have time to officially file your claim, the longer you wait makes our conversation that much harder because by then you may have severely hampered your options that would have been much simpler on day one. The safest move is to treat that first 24 hours as the start of a clock and not the end of an emergency. I've spoken with a lot of people who fail to do anything because of the worries I have already spoken about. For example, if you're a nurse, home health aide, or a hospital worker, this deadline pressure is even more real because the patient handling injuries, right? You're out there helping patients, often get brushed off as just part of the job, but they are not. A torn rotator cuff from transferring a patient is exactly the kind of injury that this process exists to protect. What actually determines whether the healthcare-specific claim holds up down the line often comes down to something we cover in more detail in another video. But the short version is this. Document it the same way you would any other work injury, immediately and in writing. If your employer tells you not to report it, threatens your job, or suggests you should just use your own health insurance instead of filing a claim, that's a huge red flag worth paying attention to. New York law prohibits retaliation against workers for filing legitimate workers' comp claims, but I've watched plenty of workers talk themselves out of filing because a supervisor made it feel like more trouble than it was worth. If your claim gets disputed, denied, or the insurance company starts pushing back on your treatment, that's usually the point where talking to a lawyer stops being optional and starts being necessary. You don't need a lawyer to report an injury, but once there's resistance, having someone who knows exactly how these claims get contested changes the outcome more often than people expect. If you've been hurt on the job in New York and you're not sure what to do next, that's what we're here for. The Disability Guys have helped injured workers across New York for over 90 years. There's a link in the description for a free consultation. Subscribe if this helped. We cover situations like this every day, every week. Has your employer's first reaction ever made a work injury harder instead of easier? Tell me what happened in the comments below.